And welcome back to Legal Matters, everyone. I'm your host, Alan Jones, and with me now is Mark Brynteson, the managing attorney with the American law firm. This is a half-hour informational news call-in show devoted to a variety of legal topics. We have attorneys standing by now to take your call at the number on your screen, 815-394-1776. They'll be able to provide you with free information on your issue. The call is confidential, so pick up the phone now and call the American law firm throughout the next hour. Again, the phone number is 815-394-1776. Now, our opening statement will discuss fee structures as well as other things to consider when you're hiring a personal injury attorney. And then after we take a short break, we'll discuss bankruptcy and the alternatives to bankruptcy that the American law firm can help you with. But first, let me remind you of the multiple practice areas in which the American law firm concentrates. The American law firm can assist you in a variety of legal matters, such as divorce and family law, bankruptcy, personal injury claims, criminal, traffic, and DUI issues, wills, trust and probate matters, real estate and business transactions, and much more. So again, please feel free to call and discuss any of these practice areas with the attorney standing by. The number on your screen again, 815-394-1776. Lawyers are standing by right now to take your call. And again, that call for you is confidential. And Mark Brynteson, thanks for being with us.
Oh, hello.
It's a pleasure for you to be here.
Yes, once again.
So let's talk about fee structure, personal injury attorney. A client walks in, has a claim, has a case. What is the one thing that a client should think about in hiring a personal injury attorney?
Well, let's talk a little bit about before we get to the fee structure.
Okay.
If I were going in to hire a personal injury attorney, and I am an attorney, but if I were going in to hire a personal injury attorney, first question I'd ask right out of the box is how long have you been practicing personal injury law? Then after I get the answer, I would then ask, well, how many jury trials have you tried and taken to verdict? And what have they been? A lot of people can take a jury or a trial to verdict, but they don't get anything. Why are they getting good verdicts? Next, I'd want a list of references. For me, I have clients that have volunteered to give references for me on cases that I've handled in the past, and just not 2 or 3. There's a lot of them. So I would ask the attorney, give me some references from past clients. Then I'd probably from there go into the fee structure. And I'd ask, well, what do you charge? Typically, you'll see in personal injury cases it's a third. Now, there are some exceptions to that. Sometimes you'll see 40%, and I can see 40% if it's a complex medical malpractice case, products liability case, because it can take 4 to 5 to 6 years to get one of those cases to conclusion, which means in an auto accident case it may be 2 to 3 at the most, but one of those it may be 4 to 6. So I understand maybe the higher percentage, but I would look for a third. And I would ask all those questions to see if the lawyer really knew what he was doing.
Just as for judgment along that line.
Yes.
Okay. Are there any cases where a contingency, as you were talking about the third, is there any cases where a contingency fee structure is not used?
Well, typically, say a divorce case, we'll do a flat fee or an hourly fee, generally flat, because it's just not called for. Contingency fees are used where, and really they're to benefit the client. When a client comes in on a personal injury case, they do not have the finances generally to, and the money that it takes to bring the case to trial, because you got to get medical records, you have to investigate the case, you have to preserve evidence. If you have to file suit, there's a filing fee. If you have to bring expert tests to testify for you, such as your treating physician, orthopedic physician, neurologist, if you have to bring them in to testify, you may have to pay them $8,000, $9,000, $10,000 to sit on the stand for one day, and that's because if they miss a day of work, they're losing a lot of money. Sure. All that money doesn't go in their pocket, but it goes to pay their help and pay them. So they are allowed to be paid, and the court will make you pay them or they don't have to testify. So there's a lot of expense that goes into taking and concluding a personal injury case. So the attorney, a good attorney, good personal injury attorney in conjunction and in addition to being able to give you all the information and all the other items I just told you about, they will have the wherewithal to take your case to trial financially, and you shouldn't have to pay them up front. You shouldn't have to pay any of the cost until the end of the case. Should
you consider an attorney who always takes it to trial instead of possibly looking at a settlement?
That depends. It's a case by case. There are some attorneys, like medical malpractice attorneys, every case is going to go to the trial because no doctor ever admits they did anything wrong. Okay, they just won't. The hospital won't admit it. They also know that because of the cost involved, they're going to see if your attorney has the money to get it to trial. So you could walk in for an appendectomy and have your foot cut off, and they're still going to take it all the way to trial. They'll just do it that way. So those cases, yes, it'll always be going to trial, but in auto accident cases, not necessarily. An attorney that has a good verdict and trial record will get good settlements, and they will be trying less cases than they settle.
Okay. Good information there for sure. Thank you, Mark, for that.
You're welcome.
Now we're going to switch gears a little bit and take a short discussion on bankruptcy, and we're going to take a quick break. We'll be right back. And welcome back, everyone. I'm your host, Alan Jones, with me, attorney Mark Brynteson with the American law firm. And you're watching Legal Matters, an informational and news call-in show devoted to a variety of legal topics. As a reminder, we have attorneys standing by now to take your call at the number on your screen, 815-394-1776. They'll provide you with free information on your legal issue. The call is confidential, so pick up the phone now and call the American law firm throughout the next hour. Again, the number is 815-394-1776. Okay, we're going to switch gears a little bit. And I know that American Law Firm takes care of bankruptcy issues, but how much of your work is in the bankruptcy area?
Substantial amount of our firm's work is in the bankruptcy area, especially with the last several years, especially from 07 through probably 2013-14, you saw a lot of people coming in with bankruptcies, but not people, also business, do business bankruptcies. So we do a substantial amount of bankruptcy.
Okay, so as a reminder, the number on your screen, 815-394-1776. There are two main types of bankruptcies. Do you do more one than the other?
Well, there's actually probably more than two. The main ones that we concentrate on are individuals, which is a Chapter 7 and a Chapter 13. A Chapter 7 is known as the complete liquidation, but that's really not a fair characterization. A lot of times when somebody comes in and they have more money going out every month than they have coming in and they need some relief, a lot of times we can allow them to keep their house or their car, so you don't necessarily lose everything in a Chapter 7 bankruptcy. Chapter 13s are for people that maybe want to keep their house, but a Chapter 7, they can't keep their house in a 7, but if they do a 13, which takes 3 to 5 years to do a workout plan, that we can structure it in a way where they can keep their house or maybe keep a business or something of that nature. But opposed to a Chapter 7, which is done in usually 6 to 8 months, a Chapter 13 takes a long time.
Is there I guess, a financial limit in which people should really consider bankruptcy? I know many people go through financial difficulties. You know, they find themselves sometimes living week to week, paycheck to paycheck. A lot of people do that. But that doesn't necessarily mean you should consider bankruptcy, does it?
Well, no. When you come in, if you were to come in to me for a bankruptcy consult because finances are troubling with you, first thing I'm going to do is find out about why you're in the position you are, and then start to drill in, does a bankruptcy really cure your problem? Sometimes it does, sometimes it doesn't. There may be things like debt workouts that could be taken care of, and we can help the client with that. But if they go to a bankruptcy, we have to drill down, and there are certain things you have to find out. Number one, you got to have more money going out than you have coming in every month. That's one of the first hurdles. Then you have to look at debt load, and I talk debt load between installment debt and what I call food, shelter, and clothing debt. Food, shelter, and clothing debt, that's a house payment, that's ComEd, that's NICOR, that's the car insurance. You're still going to have those payments after bankruptcy. It just you may be behind and you're going to bankrupt some of that debt, but that's food, shelter, and clothing debt. But then you have to go to the installment debt, credit cards, personal lines of credit, car loans, that type of thing. And you look at what the total of that debt is, and one of the questions I ask the client when they come in is, if you were to take a check and pay all that debt off, all of it today, what would it be? And then you look at what is the monthly nut or payment that it takes to service that debt, the minimum monthly payment. And then you start working through to see what could be done. And if it comes to the point where they can't eat, they can't live, they're going to shut the gas off, if there's really no alternative, then you're going to start heading down the bankruptcy route and try to see if it's a 7 or 13. So that's sort of a little bit of the analysis that we do to try to help people find out what's the best alternative.
Okay. So are there any alternatives to that?
Yeah, like I said, debt workout.
Yeah.
One of the things that isn't there, though, is you can't bankrupt federal taxes. So if you owe the tax man and you're 5 years delinquent, you can't bankrupt that. Now, what you can is try to do workouts. There are workouts where they'll reduce it. If you go to the IRS and you say, well, let's try to do a workout, and they have some amnesty programs that you can try to deal with them and work through. So you can do that contemporaneously, but if you have state and federal taxes, child support, people know child support, spousal support and divorce, you can't bankrupt that, you can't bankrupt tax liabilities. There are some things that you can't bankrupt, and it's still going to be there waiting for you at the end of the bankruptcy. But there may be some things you can do to soften the blow.
College loans, I think, are some of that too.
Yes, college loans are not bankruptable if they're government guaranteed or backed.
Yeah, okay. So the first thing, get some advice for one thing. Just because you see a bankruptcy attorney doesn't mean you're going to file for bankruptcy.
No, I mean, I would say in probably 10 to 15% of the time I find an alternative route for the client, and they're appreciative.
Yeah, I'm sure they are. All right, Mark, thank you very much for that. Thanks, Mark, for your time and insight. Once again, lawyers from the American Law Firm standing by right now. Take your call. No matter what the topic, the advice is free. 815-394-1776. We'll be back with a closing statement in a moment.